A warm welcome to this lesson series on the introduction to the Indian Constitution. In today's lesson, we will be discussing the important aspect of the amendment of the Constitution. This is discussed in part 20 of the Constitution of India. You may be familiar with this statement that the Constitution is a living document. This is also said in the context of the Constitution of the United States. It's said about India and about most of the constitutions across the world. The Constitution is expected to be a dynamic document rather than a dead document, right? So this is a document that appreciates the changes that happen in society, and therefore it has to modify itself to suit the needs of the present day. So when we talk about the amendment of the Constitution, then we basically talk about having to change the Constitution from time to time. That could happen by way of the insertion of a new provision. You may have to repeal an existing provision, or you may have to substitute an existing provision by something else. All of these would amount to amendments. The reason that you need to amend is that a document of 1949 must not become redundant in 2020 or later. Therefore, it should continue to remain relevant, and therefore it has to be changed from time to time. Also, the morals and sentiment of a society are always evolving and changing. You can see, if you look back even into the recent history, that there have been various provisions and various morals and various stands that have been changing every now and then, and the Constitution has to accommodate that. Also, the Constitution recognizes this, and the Constitution itself provides for its own amendment. The provision is Article 368, which you find in Part 20 of the Constitution. We shall have a look at that soon. Let me give you an example of why an amendment is so important. You see, the 86th Amendment Act, which we have discussed earlier, introduced Article 21A, which gives the right to education. So you see, an amendment is an important change. Alright, so let us now scroll through the Constitution of India and look for Part 20. The reason I'm scrolling this with you is to remind you that you should be able to see the contents page and be able to find what you need to within this document. So you scroll down and be familiar with all of the parts, and we are almost there. We will be seeing Part 20. So here we see Part 20, which deals with the amendment of the Constitution. And here you can see Article 368, which reads as the power of the Parliament to amend the Constitution and the procedure therefore. What that means is that one very important point that you should take from here is that it is the Parliament that can amend the Constitution. It is not the Supreme Court. Remember, the Supreme Court is not the body that can amend the Constitution. It is the Parliament. Also, Article 368 gives you both the power as well as the procedure by which an amendment must be made. Now here's an important question. Why would the Parliament want to amend the Constitution? Well, perhaps that's because it is for the good of the citizens. We just saw the example of Article 21A. It was for the good of the citizens, right? But is that always the case? I want you to think, is it possible that an amendment could adversely affect the citizens? I would like to draw your attention to one point that I had made in our previous lesson. It was about the fact that fundamental rights are a negative obligation of the state, right? Which means that if the citizens get a fundamental right, then the state has to fulfill a duty, which means that when citizens get fundamental rights, then the load on the state increases and the power of the state reduces. So when citizens get fundamental rights, then the power of the state reduces. So that's a decrease in the power of the state. Therefore, when the state wants to assert its power, right? When it wants to show that it is powerful, what does it do? It abridges fundamental rights. It takes away fundamental rights. Okay? So therefore, this is a very real threat. Okay? It's possible that when the state wants to assert itself and wants to become powerful, then it will do so by taking away the freedom of speech. For example, let us say if you have the freedom of speech under Article 19, okay, you have the freedom of speech and expression. Now suppose this right is taken away from you, then you cannot protest. And if you cannot protest, then the government can continue to do what it wants to. Therefore, this is important to be safeguarded. And therefore, we should always remember that an amendment need not necessarily be for the better of the citizens. So let us come to the most important question. Can the fundamental rights be amended? Let's take it like this. Can Article 14, which assures the right to equality, can Article 14 be deleted through an amendment? Can the word democracy be removed from the preamble of the Constitution? So we no longer have elections, and then what we have is a monarchy, so that the son of the Prime Minister becomes the next Prime Minister. Is that possible? Or let us say we have around 470 articles as of now in the Constitution. Can 200 new articles be inserted into the Constitution in one day? Is that possible? Can the Constitution be amended in this manner? So, can the Parliament amend any part of the Constitution? Does it have that power? So we saw Article 368, which gives the Parliament the power to amend, right? So can it amend any part of the Constitution? The answer to that is yes. Article 368 gives very wide powers to the Parliament. It gives the Parliament plenary powers. Okay. So again, I ask you the same question. Can Part 3 be amended? Let me remind you, Part 3 basically refers to fundamental rights. Right. So we've seen that Part 3 is fundamental rights, Part 4 is DPSP, Part 4A is fundamental duties. So can Part 3 be amended? Because Parliament can amend anything. The answer to that is no. It is not easy for Part 3 to be amended. So before we proceed any further, I would have to explain to you this concept of basic structure. Now, let's take an example. Let's take an example of, say, my own self. Okay. So let's say this is me and I wear specs and I have some beard and I have a nose, a mouth, and I don't have hair. Yeah, so this looks like me. Now, is it possible for me to bring about a change in myself? Let's say I go to this hair specialist and I say that, hey, give me some hair, and I become this guy. So this person earlier was Ankit. After the hair, he is still Ankit. Okay. Then I decide that, okay, these specs are not nice. Let me get rid of these specs. I want to be able to show my eyes. So what I do is that I go for a LASIK surgery, and now I have these eyes without the specs. Okay, so forgive my drawing, but yeah, you get the point. So now this is Ankit without the specs and with some hair. Is this still Ankit? Yes, it is Ankit. He's been amended. Now I decide that I am too skinny. Okay, so I decide that, okay, let's get some steroids and I'll pump myself up. So now what happens is the skinny guy starts to become big. So now his arms are like this. So this is now me. Now, is this still Ankit? At some point, you might realize that the changes start to change the person at a very basic level. For example, let us say this is the person. Maybe you can chop one limb off. So a person without his hand continues to survive. But if you chop off the head of that person, the person himself ceases to live. And you remember, we discussed that the Constitution is a living document. So you have to treat it like a living document. If you amend the Constitution so much that it is no longer the original Constitution, then you have violated its basic structure. Alright? So what do we mean by basic structure? Basic structure means that there are some things, some elements that are very fundamental, that are very basic, that are very intrinsic, that are very important as far as the Constitution is concerned. If you amend these parts of the Constitution, then it amounts to getting a new Constitution altogether, right? And Article 368 does not allow for a new Constitution. It only allows you to change the old Constitution, right? The old Constitution can be changed, but you can't change it so much that it becomes an altogether new Constitution, right? Which means that the basic structure of the Constitution has to be preserved. Okay? And this brings us to what is called the doctrine of basic structure. This was propounded in the case of Keshwanand Bharati versus the state of Kerala. As I've told you several times, this is perhaps the most celebrated case in the history of Indian jurisprudence. So this was a 13-judge bench, which is the largest bench ever. There has never otherwise been a 13-judge bench for any matter before the court in India. Also, it has been the longest hearing ever. Okay, and it's a landmark judgment for securing fundamental rights. So this doctrine of basic structure was given in this case of Keshwanand Bharati versus the state of Kerala, where it was held that the constitution can be amended. True, the parliament has the power to amend the constitution, but it cannot amend it to an extent that the basic structure is altered. So the doctrine of basic structure says that the basic structure of the constitution cannot be altered. Right? So this is the doctrine of basic structure. So if I ask you the same questions again, can Article 14 be deleted? Can the word democracy be removed? Can you add 200 articles or can you remove 200 articles in one day? The answer to that is no. And the reason for that is what we understand as the doctrine of basic structure. Now, I will just talk about one or two important amendments that have taken place in the Constitution because these are very significant ones. I'll start, of course, with the 42nd Amendment Act of 1976. This Amendment Act is so important that I would say, let us say you are asked a question, okay, you are given a question as to when a certain amendment took place and you don't know the answer and you have to take a guess. I would say your guess should be the 42nd Amendment Act, because the 42nd Amendment Act is such an extensive amendment that it is sometimes called the mini constitution, right? It has changed the constitution very dramatically, right? It has introduced a change in almost every part of the constitution, including the preamble, okay? So this was introduced during the emergency period when Indira Gandhi was the Prime Minister. So that was the importance and the significance of the time when these amendments were brought about. Understanding the political climate helps us better understand as to why these amendments were brought about. Likewise, when we talk about the 42nd Amendment Act, then it is also helpful to talk about the 44th Amendment Act, which is also a very significant and major amendment act. This was brought about by the Janata government that came into power after the emergency, right? The Janata government came into power because it promised the people that it would undo what was done in the 42nd Amendment. So the 44th Amendment Act was basically aimed at counteracting what was done in the 42nd Amendment Act. It was not entirely a successful thing, and there are many provisions of the 44th Amendment Act that have not come into force. But still, you know as to what the reason for the 44th Amendment Act was and as to what the political climate was. So I hope that you have got an idea of amendments and that you've learned something from this lesson. Thank you very much for your patience. I wish you a good day. Thank you.